Special Education Presentation by Taylor Brooks, or also known as Legal Rights and Representation. What is special education? According to our textbook, special education is defined as specially designed instruction to meet the unique needs of an individual recognized as exceptional or with special needs. This means that a teacher must be able to create a program for a special needs student and make sure that the student can succeed in an academic format, such as at school. These given students are given accommodations such as extra time on test, usually a time and a half, than the regular time, separate test rooms, so like in a different room, breaking down larger projects, so essays, be like, you need to have this done at this time, this done at this time, unlike other students who have to have it done in a certain time. And then adjusting the teaching styles for the physical disabilities. The IDEA principles. The 6 IDEA principles is an appropriate special education. A school cannot restrict a student from getting what they deserve simply because they have special needs. For example, if a student was blind, they will need access to Braille, which is a bump form of communication. So they touch the Braille, the bumps, and it spells out what it is. As access for their schoolwork, and school cannot deny that right. The next one is a least restrictive environment. Make sure you put your students in an appropriate classroom and grade level that is needed. If they are able to go into mainstream classrooms, then you should place them accordingly in order to allow the student to develop normally and get skills that they need. Some students don't go into mainstream classrooms, they go into less restrictive classrooms, which a teacher comes in and they're one-on-one, or they do half and half. And then there's the IEP, which is a document that is made as a collaborational effort between the school and the parents of the student. It creates a path for them educationally to follow up. On paper, it set goals such as you need to have this. This is going to be the reading level for this week or this month or this year, and then they're going to evaluate at the end of year to see if they work. And it also provides accommodations such as I said in the first one, for students will receive, and then there's meetings to make sure that the students are on track. Procedural due process, which is the rights for parents to see the documents, such as IEPs, and if they decide to change it and the parents are like, no, that's not okay, they're allowed to sue the school, and that's okay. And then there's non-discriminatory assessment, which the assessment that a student is given cannot be biased against their social, economic, or cultural standing. The test must be equal for everyone. So you can't give a person who is Hispanic a different test than a student that is white, for example. Parental participation is also required for involvement in the educational situations. So they have to be there for IEPs, anytime they want to change the IEPs. So, what isn't special education? Something that isn't special education is a handicap, which is described as a difficulty imposed by the environment or a person with a disability. So, for example, if a person was in a wheelchair, that's not described as a disability. The PL 94-142, which was in 1975, this law is mentioned in Chapter 2, which is public law, and it also is known as the IDEA Act, which I mentioned the 6 aspects earlier, which makes sure that special education kids with special needs that are in special education had the appropriate standards met and protected under this law and the unique needs. So basically, they're allowed what they deserve. And then there's Public Law 99-457, which was in 1986. And in 1986, this law said that it is required services for preschool students, which, and it does intervention for toddlers and infants with disabilities. And this actually became big when they were only giving students that are in like elementary school and stuff and they thought, oh, that's not fair, because there should be early intervention to help students with disabilities. It has also provided a ISFP, which is an individual family service plan, which was made for toddlers and infants with developmental delays, which was a term created during this law. In 1990, it was revised again and named the Individual with Disability Education Act. Autism, brain trauma were identified in this discrete disability category. Then the next slide is Public Law 101-476, which was in 1990. In 1990, it revised again, and it was named the Individuals with Disability Education Act. As I said, autism and brain trauma were identified in discrete disability category. It created rehab counseling, social work categories to make them labeled related services, and the requirement of the individual transition plan was created. It was changed 7 years later. Students with disabilities were required to take district-wide assessments, which are like tests to determine whether or not what their grade level, if they're in the right grade level, right classes, making sure that they understand each thing, and if so, they do not okay on that, then they are brought to a special education. They are brought to get a special education assessment and figured out that way. This transition plan started at 19, and the orientation and mobility was included to the related services. And then, as I said, they used the developmentally delayed, so not like not like a learning disability, basically. And this was for children who were 4 to 9. And then there was Public Law 105-17, which was in 1997, and it required students with disabilities to participate in district-wide assessments. As I said, district-wide assessments are school-wide, so like Tulsa Public Schools is a district and that type of stuff. Orientation and mobility was also included, as I said. General education educators were required to participate in the IEP teams, which means just regular educators instead of just special educators. Special education educators were there to give their input on the IEP of the student that it was involving. So, and then students with disabilities are to be involved with and to have access to general education. So they can't just be only special education. They're allowed under IDEA also to get appropriate education. So if they're ready for regular mainstream classroom, they're allowed it. And then there was the No Child Left Behind Act that Bill Clinton put in office, when he was in office. It was in 2001. And it says that every student, including special education students, were tested from grades 3 through 8. And they did everything except for science. So math, reading, English. And so not until 10 through 12th grade, they were required to take the assessment at least once, but for 3 through 8th graders, they had to take it at least twice. And what I thought was weird is that 9th grade is not included in this, which is weird, because that is also a high school grade. Schools were required to show progress towards a universal goal of 100%. Schools were experienced difficulty obtaining the goal of 100%, were given financial and technical assistance. So basically, if a school did not get 100%, like all the students get not 100%, but like past what they were supposed to get, they were given financial to help get to that goal, or technical support. Like, for example, if a student needed a computer to take the test instead of a piece of paper, that would be considered. And then in 2004, there was the Individuals with Disabilities Improvement Act, which included an RTI in response to a student's achievement. And then an IP must include a statement of the performance and goals. So basically, it had to be like, this person is performing above or below what we set. And then another thing is, all people are to be included in a district-wide assessment with accommodations based on their IEP. So basically, even special education students had to take it, but they got their accommodations, such as extra time, taking it in a different classroom, taking it one subject at a time, having it read to them, having it on a computer, those type of things. Special educators must be highly qualified. So basically, if they were not highly qualified under, like, it doesn't say that they're highly qualified, so they didn't get they had to have a really good, I guess you would say, like, they knew what they were doing, and they had more experience than other teachers that were there for the job, and that you were trying, I guess that's what you're saying, but and then there was the Every Student Succeeds Act, or the ESA Act, which was signed into office by Barack Obama, and it brought back the Elementary and Secondary Education Act of 1965, also known as the No Child Left Behind Act, that was instated by Bill Clinton. The elementary test will have reading, math, and once they get into high school, there will be like a big science test, a comprehensive science test of all of the grades. So basically through what they learned until they got up to high school in science and math. And it was changed from a yearly assessment to a statewide accountability system. So basically they were making sure, instead of doing a yearly test, they were making sure that they were on track for that 100% that they were supposed to make. The states were allowed to adopt the Common Core state standards, but they were not required to. Some states did, some states didn't. As it says in the No Child Left Behind Act, teachers had to be highly qualified, which was taken off in this act because the president believed that every teacher was highly qualified for their job and didn't think it was appropriate to say highly qualified when he believed they were all highly qualified. Keeping requirements that achievement data be categorized by multiple factors, so like race, disability, age, and then or economic status. Interventions will start at the school. The school is at below 65% graduation rate, which is not very good. The IDEA students, so the kids under the IDEA Act, get everything from the previous act, which was the previous act, and they have to use the school-wide rules as well as evidence-based intervention. And then there is the Section 504 of the Rehab Act of 1973. It prohibits people from being discriminated against based on their disability. So basically, this act told people that if a person comes in wanting a job who has a disability, cannot be not chosen over a person who doesn't have a disability if the person with the disability has more qualifications than the person without the disability. So a boss can't be like, this person without the disability doesn't have as much qualification, but I wouldn't have to deal with them and than having a employee that's disabled and dealing with more money issues to get what they need. They are legally able to get into any government-funded program, and it can be any age compared to the IDEA Act, which was 3 to 21. It made a wider net of definition for for people with disabilities, not just for basic disabilities that were more well known. So basically, it was more than just ADHD, Asperger's, ADD, autism. It had more wide variability on things that maybe we haven't heard of. Instead of an IEP, it was referred to as a accommodation plan. So basically, they just changed the name. We have to have an assessment like before, but it is not limited to your ethnicity, social economic status, etc. If any changes in education were to occur, and an evaluation must take place. So, for example, a restricted classroom to a mainstream classroom, the student must be evaluated on whether or not that is the right fit for the student or not. And if this was changed, as it was in other laws, if this is kind of like similar to the other laws, so if it was changed without a parent's permission or the parent did not agree with that and they still changed it, the parent had the right to get a lawyer. And then there's Public Law 101-336, the American with Disabilities Act. And it's, if anything keeps an American with a disability from doing something, they were covered under this legislation. Protection of civil rights, employment, transportation, and telecommunication, not telemarketing, excuse me. And basically it said that people basically that they had to abide or make accommodations for the people with disabilities to make sure that they were treated appropriately. There were also private sector accommodations as well. If an employer of 15 or more workers, they must have reasonable accommodations for the individual that was disabled, but it can't discriminate against them. It has to make sure that they are still treated like a normal person. For example, braille keepers, ramps for people with disabilities, mass transit systems must have easy access. So if a person was in a wheelchair, they had to have that machine that at the back of the bus or the front of the bus that holds up, that can help put the person in the wheelchair into the bus. Hotels must have be able to accommodate people with disabilities. Fast food restaurants, banks, coffee shops, they must have an alternate way of providing services. For example, I saw this thing on Facebook where this Starbucks employee who knew sign language, if a deaf person came through the drive-thru, that the barista would pop up on the screen and do sign language to the individual to see what they wanted to drink or order. And I thought that was pretty awesome. And then there's also, if a person is deaf or hard of hearing, they are required to provide a video phone or an interpreter. And then the next law is Public Law 110-325, the American Disability Act Amendment. It's also known as the ADAA revision. It was the revised definition of disabilities, including broader terms. It expanded the ADA, defined as major life activities, including to list of activities that are not bodily functions and ones that are. States that interpretation of substantial limitations must include medications, treatments, therapies, doctor's appointments, and the only thing that this excludes is eyeglasses and contacts. The Section 505 protects students with disabilities and covers more students under broader terms. However, a student cannot be covered in less than 6 months if a disability is considered minor. So basically, if a student were to, get eye surgery and they were only, couldn't see for 6 months, that wouldn't count. This had a significant impact on the special education community. So the rights of parents, students, and family and teachers. So for students in 1970, 1979, and 1989, the right to class placement could not place a special education placed in special education because of a cultural race factor. So basically, if a school thought just because this person is Hispanic, they couldn't be placed, and they had no other factors of needing special education, they couldn't be placed in special education. The correct restrictive environment for severe disabilities and provisions of supplement aids and appropriate integration. And then in 1972 and 1977, the right to education, contractual rights to specialized instruction, so free public education to all students with disabilities. And then in 1974, there was the equal education opportunities, accommodations made for non-English English-speaking students required to offer language assessments. And then in that same year, extended school years allowed a school-wide education such as summer school. So basically they were supposed to have free appropriate education. So basically people couldn't be like, you're not allowed to have summer school because that is not in the law, but that is not true. In 1980 and then in 1999, related services, not discriminating against what a related service would be for a special education student, intense and healthcare services necessary to attend school were not provided. And then in 1982, appropriate education, and then the right to appropriate education for a student with hearing impairment. So basically, if a student had a hearing impairment, the school had to require an interpreter or the technology for the student to succeed in the academic format. And then in 1992, the least restrictive environment, a placement in gen ed classroom must be offered first to a student before segregating placement. So basically, a student must be offered to be in a regular classroom before they are put into a special education classroom. And then the rights of teachers, this happened in 1997, was the provision of services. It's the right to teach students with special needs with public resources in public or private schools. And then in 2005, there was a burden of proof that did not change IEPs without meeting with the parents. And then the parents and families' rights. So in 2005, they also have the right to burden of proof placed upon parties seeking relief. A parent has the right to sue the school if they see fit, thinking that the IEP has been tampered with in any way and not approved. So basically, if a school says, hey, this person needs to be changed into a less restrictive environment, and the parents did not approve that, and the school still did it, they're allowed to be sued. They're allowed to sue the school. And then in 2006, that goes on with that. Parents have the right to get their money back if they sue the school. And request a special education specialist. And then that next year, parental rights, the parents have the right to go to court in a IDEA-related case if they see fit. And then in 2009, the tutor reimbursement IDEA authorized reimbursement when a family moved to a private school when a public school failed to provide services. So basically, it's what it sounds like. So if a public school was like, I'm not going to provide an interpreter for you, or things that the student needed, the school could, the parents can move the student into a private school, and they would be paid back for that. And then there's this such thing as a referral, which is a general education teacher can help a student who is having difficulty by helping because they are not in the line of getting a special education, so they have like trouble, but they're not like borderline getting into special education. The teacher can help a student who is borderline in getting referral to be in special education, so the teacher offers help so that they are less necessary for referral, so like extra tutoring and that type of stuff. Collaboration between general educators with other professionals for creating alternatives to accommodations of the needs of the learner. And then there's the referral. A referral is a request made by a concerned adult, such as a teacher or parent, or a guardian, to see if a student has a disability or not. The first step towards getting officially into special education is a special education intervention program. And then the child find is required by state and is mandated for students who may need special education services to have the right to them. A referral can be initiated because of a linguistic background and can be caused also by teacher bias or poor judgment. So if a teacher was like, this student isn't doing good in this, I think they have they can't do that. That they need special education. They can't do that. About 75% result in placement, and 25 are found manageable. Must tell why they are being referred. Teacher also must show how the student acts academically and must show evidence, so like test grades, schoolwork, that type of stuff. And then there is assessments, which is a group of tests to figure out the strengths and weaknesses of a child in certain subjects such as math, science, that type of stuff. They have to have a parent's permission to do the assessment. And then it requires a group of professionals and different backgrounds, such as different subjects, who are teamed to figure out the exact diagnosis of the student. A student is allowed accommodations for their assessment, such as large print, braille, extra time, breaks, that type of stuff. So my philosophy on special education is that it's an essential part of a student with special needs or a disability. I found that special education personally to be essential since I have a disability, which is dyslexia, Asperger's, dysgraphia, that type of stuff. I like the rules that are in place currently, but there is still more changes that can be done to better help the students with special needs. For example, with accommodations, the school that I have experienced when I went to school, they only give us an 1.5 hour extension, and maybe like 2 hours would be better. And then also, this may not just be for special education, but it is not fair for people to take one test to get verified, such as like for, how like in Oklahoma, you can take an emergency certification and you're allowed to teach. I don't think that's fair, because the tests do not encompass the strategies that you need to be a special education teacher. First-hand experience is needed in order to fully understand how to deal with severe disabilities. In my classroom, I will be able to bring my experience with having disabilities to my students so they feel more normal and at ease when doing activities and homework, so I can give them my experience. I also implement testing accommodations and learning about the history that makes the experience easier. And that is my project. Thank you.